Good evening, everybody. At the outset, I thank Dr. Kalpana Suresh and Dr. Chandrasekhar for giving me this opportunity. You must know that ignorance of law is not an excuse. The advocate may even say that there was dedicated instruction course on how to maintain records, and if you didn't attend, it is your fault. So, you see, the advocates do not come under Consumer Act, but doctors have. You must be wondering why it is so, and you must be wondering why the seniors did not take any action about this. It is again because of our ignorance. When the IMA people went to Mr. Parasharan, who is a very famous advocate, he was even an Attorney General, his fees at that time was 1 lakh for every 10 minutes. And the IMA people went and asked him. His assistant told them to formulate all the questions in advance so that they won't waste time and finish it off in 10 minutes time. So they went and asked him about this Consumer Act. He then asked how many doctors were there in the IMA. They said hardly 20-25%. He immediately said, you are not a representative of the doctors, so we cannot even contest. And the next question he asked was, why we were keeping quiet for such a long time? Because for any act to come into force, it takes 7 years. So, and what advocates did, as soon as the discussion was there in the Lok Sabha, they stopped it. That act has to pass in Lok Sabha, go to Rajya Sabha, go to President for signature, come back to Rajya Sabha, then to Lok Sabha, then only it will come into an act. So all this time we have slept. So at least now we should wake up so that we can protect ourselves. So poor records mean poor defense, no records, no defense. So whenever a patient says that there is negligence, it's only because the records are not there. Dr. Nirmal Frederick said so much about the consent form. You must be, recently there was a case where a patient lost the voice after a thyroid surgery. He went into the court, but in the consent form it was clearly mentioned that the voice can go after thyroid surgery, and the case was given in favor of the doctor. So if you see in Australia, they even take consent in the cataract consent. It is mentioned that they may even get sympathetic ophthalmology. To that extent, all the complications must be entered in the consent form. Then you won't have any problems. So in the records, most of the things have already been told by the other speakers, so I will go fast. So all the findings should be noted in the case sheet, and the doctor should check the record room regularly. He cannot tell that the medical records person is in charge of maintaining the records and escape. The doctors are legally supposed to visit the record room regularly and then see to that the records are kept properly. The chronology must be correct. You cannot tell 7th, you can mention something and then later on you can enter the date 5th and enter something else. It is not accepted. And even the clippings must be proper, and the description of test results must be clearly written, and index coding wherever it is there, it must be entered. Now that most of the patients are going in for insurance, they have an index coding for all cases that must be noted, and nurses' records must be inspected by the doctor, and summary should be written in all the case sheets when the patient is going out of the hospital. And as per Indian Evidence Act 1982 itself, it was there. It was amended in 1961, and records written after the death of the patient is not accepted. So whatever complication is occurring, you must see to that it is entered immediately. And as Dr. Kalpana has said, if there is any error, you have to just strike off. The person who is examining the record must be able to read whatever has been struck out, and you have to give the correction. And in criminal cases, all the corroborative nature of the weapon, cause of death, which is not for us, it must be kept. And regarding this factor, when I asked my daughter's friend, who is an advocate, to ask about this subject, she said she already has got 2 cases regarding this medical records keeping, and she immediately gave me all these facts. So it is not something like which is not happening. criminal cases, it has whenever criminal cases or medical legal cases are there, till the cases are disposed of, all the case sheets must be kept in original. And if the court asks the doctor to appear, he has to appear, otherwise he can send a representative. And inpatient's records must be preserved for 3 years. And records, if say somebody is referring, some patient is coming to you for a second opinion, you can always ask for all the records from the previous hospital. Because most of them, they go to many corporate hospitals, they come to you for a second opinion. Within 72 hours, the previous hospital has to give all the records if the patient or the patient's attendant asks for it. And regarding the register of certificates, whoever is giving a certificate must have a copy of the certificate with them. They cannot tell that they didn't give the certificate or anything like that. They have to have a separate copy of the certificate in another diary. Even whether you are in a government hospital or in any other hospital, you are supposed to have a copy of the certificate. And computerization is preferred, but a hard copy of the records with the doctor's signature must be there. And there is no definite guideline regarding for how many years it should be kept. We can tell that it is 3 years and all that, NCA is told, but legally there is no point like that. So we doctors have to fight for that also. We cannot keep the records forever. And when a child is there, like Dr. Chandrasekhar said, till the child attains the 21 years, and 3 years after that, the records have to be kept. And if there is a legal problem, again as I told you, till the case is disposed of, all the records must be kept in original. So proper consent with all possible complications should be there. And if the bill is given in the hospital letterhead, the hospital also is responsible. So if you are running a nursing home, somebody else comes and operates, and if the bill is given in your nursing home's letterhead, the owner of the hospital or nursing home also is responsible for any complication which is contested by the patient. And name of the anesthetist must be there. Most often we give the anesthesia ourselves, and we may keep an anesthetist by the side or not. And nowadays most of the nursing homes insist on an anesthetist being there. So the name of the anesthetist must be there. And prescription must be legible. If your handwriting is not good, better to write everything in the capital letters. Date, time, day, signature, which has been told.